Good morning once again. My name is Makongo Boniface. I'm the Chief Legal Officer at the Competition Authority. This morning, I'm privileged to share with you what we do at the authority. My presentation is on the regulatory issues, but I'll concentrate more on mergers because that's essentially what So I'll concentrate more on mergers because that is essentially what, where we have most contact with the legal profession in this country. I would just want to emphasize that this is a fairly new area of law, and according to me, it's relatively very lucrative. It's very straightforward in terms of what the input of the legal practitioner, because it does not involve a lot of work. So I would advise that most counsel consider venturing into this area of practice, because currently we have very few law firms dominating this area of law, just around the 5 major law firms which I handle most of the work comes only from about 5 law firms. I'll appreciate if all the others took up this area. So the first thing I want to introduce you to is basically the brief outline of what I'll be presenting. I'll go through the mandate of the authority, mergers and acquisitions in detail, basically to appraise you on the process. And then I'll go to the regulatory focus of the authority. And lastly, I will handle the current challenges we're experiencing in regulating the area of competition. Now, the Competition Authority of Kenya was established by an Act of Parliament, the Competition Act, which has been enforced since 2011. And the mandate of the authority essentially is to promote and safeguard competition in the economy and also protect consumer welfare. This Act also has established a tribunal which handles, basically, it's an appellate tribunal for all the decisions of the authority in most of the areas which the previous presenter mentioned. This authority was previously a department of the Treasury when it was implementing the Restricted Trade Practices Act, which has now been repealed. Now, the mandate of the authority is fourfold, I mean. The first is that we regulate market conduct. Market conduct essentially means how traders conduct themselves in the market. And in this regard, what we do is we essentially we ensure that we prohibit the restricted trade practices by traders, associations, as you've been told by the previous presenter, and also abuse of dominance. You're aware there are some firms in this country, in almost all sectors, you find firms that are very dominant in almost the sector. So we want to ensure that the consumer does not lose out as a result of the dominance of the firms. The next area of our mandate is regulating the market structure. With regard to the market structure, essentially what we do is that the key and core area here is regulation of approval of the mergers and acquisitions, so that we ensure that when firms merge, there are no negative consequences for the consumer. We also handle consumer welfare issues under the Act and advise the government on competition policy. Now, because of the way we are constituted, because we basically we regulate the entire economy, we have to work very closely with the other established regulatory agencies, which are mentioned there. And also the law requires of us to establish frameworks to manage the relationship, because also in this area, we tend to handle a lot of very confidential information. So we have to have frameworks that enable us to handle information among sector regulators to ensure that the market players do not lose out by dealing with us. Now I'll go straight to the issue of mergers. It has been defined, so I'll just basically go straight to the process. Now it's a requirement, as the previous presenter said, that you must, currently the way the law is drafted, it would imply that all transactions have to be approved by the authority. There is a provision for exclusion of certain merger applications. But unfortunately, we have set out thresholds for what, below which my previous presenter also stated about, below which we basically just give exclusions because they have no significant, those kind of transactions have no significant effect on competition in the market. Now, once you have applied for your file for notification of a merger, we require that you give us a sale agreement, you give us the income statement and balance sheet, and for listed company, we want the listing particulars, and we're also very keen on the relevant board document. The reason why we're very keen on the relevant board documents is that we want to see why you felt that it was necessary to merge to remain in the market. So we look at the board document, then we see the strategy, what is informing your strategy of the merger. And from there, we're able to determine whether really the merger is harmless to competition or not. Currently, we're not charging any fee for this service, but in future, we intend to charge, especially for the bigger mergers. Now, once we receive an application as the authority, what we do first is we acknowledge it, we inform you that we receive the application, then we carry out a preliminary assessment of the application, and if it's a small merger which has no anti-competitive effect, we straight away inform you that you can go ahead. Otherwise, if it falls within the threshold which we've set, the next stage is we carry out a comprehensive evaluation. We go through our board, it approves the transaction, then we issue you with a notice of determination. And we are required, of course, to gazette the merger. Now, the timelines that we follow are statutory because in this area of operation, you're dealing with investors, people who have borrowed money. So we have very clear timelines within which you're supposed to give feedback to the market players. Now, if you bring an application and there are no major issues, we don't seek any further information to understand the nature of the transaction, we get back to you maximum 60 days. And as the previous presenter who's a practitioner has just informed you, realistically it's more or less between 30 and 45 days. Now, in some instances, we actually need to seek further information because some mergers have international effect and all that. Others are very complicated. Now, in that case, then we ask for information. We are required to ask for this information within 30 days. And then after 60 days after receipt of the information, then we get back to you with either an approval, also rejection, we are allowed to decline an application, or we can give an approval with conditions. Now, the actual merger analysis is not really a legal process. The actual merger analysis is an economic assessment. So what the considerations the economists look at when they are assessing the merger, I'll lay them out. First of all, they define what the market you're operating in. They look at the product and the geographical market you're operating in. They look, because we are keen on competition, we want to ensure that the consumer does not lose out as a result of the merger. We look at whether the consumer has substitutes and alternatives to the products that the merged entity will be producing. And then we also identify the participants that are in the market and their respective market share. So that, for instance, if you are Coca-Cola, maybe having 60% or 90%, and you want to merge another firm which has 10%, we will not allow such a merger because the effects on competition will be there. And then we also look at market power. Market power basically is the ability of firms to either enter or leave a business or a market segment. So after this economic assessment has been done, of course we now have the statistics, now we go for the legal consideration. The key legal consideration is whether or not the merged entity will either lessen or prevent competition. But there are also public interest considerations which are very key when we are approving a merger. We also look at the effect on employment. You know very well that this country, a lot of the unemployment rate is very high. So we want to know the effect on what will happen to the staff who are in one of the, for instance, the firms which is being acquired. We also look at public benefit. In this regard, there's a failing firm. If a firm is failing, for instance, and somebody comes in to buy it, it's in public interest that if the person will take over the operation and rescue the enterprise, it will be for public benefit that the merger is approved, so we can approve on those grounds. But the key consideration is the competition aspect. What is the effect on competition? And then the other issues we look at is also, you know, we are a developing country, but we need to have strong enterprises that can compete internationally. So if the effect of the merger is to do that, we'll also approve it. We also look at the effect of the merger on the sector. Does this make you dominant so that you will always be able to determine price to the detriment of the other players? So those are the key considerations. And after this, we then get back to you. Now, the next issue, which has also been handled partly, is the issue of the consequences for not seeking our approval. There are quite a number of firms, because of ignorance, or maybe they didn't know that this law exists, who have gone ahead and completed mergers without seeking our approval. The first thing is that the law is very explicit, the Competition Act, that this particular merger, which you conclude without our approval, has no legal effect. So the obligations it imposes cannot be enforced by law. But there's also the criminal angle. We can have you liaison in the DPP's office. We can have you charged, and you will be fined 5 million or 5 years in jail, or both. But also internally, we have an administrative process, and pursuant to which we can penalize you to pay us 10% of your turnover for the preceding year. Now, next, with regard to the regulatory focus of the authority, I told you that we are a fairly new institution, but currently we are handling about 70 mergers per year, excluding the exclusions that we give, which don't fall within the thresholds. So we want to, as we'll see later, we want to improve on this area so that most of the transactions that are happening in this country actually have the force of law. The next area of focus for us is market inquiries. We want to make inquiries into various sectors. We are currently about to commence a banking sector inquiry, essentially to establish what competition concerns there are, whether there are concerted practices in those sectors, what happens so that we can unlock the potential in those sectors and allow for the consumer to benefit by way of reduced prices, in the case of banking, reduced interest rates. That we will be commencing briefly. We also, because of our nature of our mandates, we setting up interaction frameworks with the sector regulators. You realize most of the sector regulators also have more or less concurrent jurisdiction in this area. So if, for instance, you're handling an issue to do with telephony, you want to come up with a framework with the Communications Commission so that you don't have a lot of duplication. We're also carrying out a product market regulation study. The purpose of this study is basically to go through all the corpus of our laws and establish and pinpoint which ones have anti-competitive effect. Most of them, you know, some of them are relatively old laws. And after we've done this study, we'll now do an advocacy with the respective ministries to ensure that those laws are amended. We have also realized with the coming in of the county governments that there are some of them that are engaged in practices that are very detrimental to competition. And in this regard, we are also doing a lot in this area to liaise with the counties to ensure that they do not engage in that conduct. Then I want to go to the issue of the tribunal. The tribunal has been said not to exist. Unfortunately, I want to clarify that the tribunal has actually been gazetted. The chairman is a Mr. Mukuha. Unfortunately, no cases have been filed before the tribunal. The tendency in this country is once a client comes to you, you only think of going to court. So what happens is we have a lot of court cases, people challenging our decisions, but there's nobody going to the tribunal. And in fact, when we go to court, this is one of the issues we raise as our defense. That, look, I mean, there's a tribunal here, how comes you're not going to it? And in some cases, we have had decisions in our favor. Now, the tribunal has jurisdiction over the entire corpus of our mandate, from decisions with the authority makes on restrictive trade practices, abuse of dominance, handling confidential information, mergers and acquisitions, and even consumer issues and unwarranted concentration of economic power. And every section of the Act essentially sets out the timelines for approaching the tribunal and the timelines within which it should give its decision. And of course, appeals from the tribunal lie in the High Court. Now, as an authority for the future, we are looking at creating transparent systems so that when you apply to, for instance, for merger, we want to have clear guidelines. We have guidelines on exclusions and thresholds for mergers, for instance, but we need them to have force of law, so we're already engaging the relevant government department so that the law is amended accordingly, so that the regulations then are set out clear, whatever guidelines, or even when we are handling an issue and say it's a public interest guideline we are relying on, it needs to be very clear to the public what exactly we are doing. We're also having guidelines on exemptions and on exclusions, which once the regulations are made and by the Cabinet Secretary, this will help in clarifying the implementation of this act. We also engage in advocacy. There are a lot of laws I told you which have hindered competition in very many sectors in this economy. So we want to do advocacy so that we address that. And we're also carrying out market inquiries, as I've mentioned. We also realize that this area of law has very little scholarship going on in universities, so we are having a lot of MOUs with universities to sponsor programs, master's programs, for instance, for people interested in this area of study. One of the programs we have with the University of Nairobi is about to kick off, and that advice council, once the opportunity arises, maybe we could consider that area for our master's study. We also engage stakeholders through workshops. Our next workshop is in February 19th, and it will be basically on the merger notification process. We are coming up with a new form. We're also suggesting to charge fees for slightly bigger mergers. So this is a workshop where we'll engage you. Most of our stakeholders in the merger review are actually lawyers, but I hope more of you attend, subject of course to availability of space. Now, on the East African competition law, the other presenter had talked about COMESA. There's also an East African competition law. This law is not yet operationalized, but it's about to. But unlike the COMESA one, this one comes out very clearly. You realize that in COMESA, the way they have interpreted their mandate is such that even if you had a merger going on, probably in Mandera, you would still fall under their jurisdiction, because they say that they have jurisdiction over any merger which has an effect in the COMESA region. That is a very wide interpretation. And also they are reluctant when people apply. We have had instances where people approach them and say, look, can you give us an advice whether our transaction falls within your jurisdiction? The first thing they say is file the application first, then we'll look at it. And the filing fees is $500,000. That is quite high for most enterprises, even successful ones in these economies. So the East African competition law is slightly an improvement over that. And it governs more or less the same things as our Competition Act, concerted practices, abuse of dominance, mergers, and consumer welfare issues, with a cross-border effect, essentially within the East African region. But you realize now that some of these are political issues. Like, we'll need to have a clear delineation between COMESA, EAC, and the national authorities like ourselves, because potentially it would be very difficult to comply with three laws. For instance, if somebody is a country is a partner state to EAC, they are also in COMESA, you have a problem where you may be compelled to seek all the approvals, which may be very negative to business. Now, the decisions, maybe what you need to know is that the decisions of the EAC authority, once it's in place, will be binding on partner states. And in case of a legal dispute, there will be a requirement that once the EAC authority is seized of the dispute, you wait, you stay the similar disputes or related disputes in the local jurisdiction, in the local courts, until the EAC authority dispenses with it, then you can go on. A unique feature of this EAC competition law is the fact that it also governs the issue of subsidies by states. And the intention here is to avoid a situation where countries in the EAC region give each other subsidies that have a competitive effect in the region, because we are now operating on a common market, more or less, regime. Now, lastly, the key challenges that we are encountering is one, the one I've mentioned about overlapping jurisdictions. We have, you have a situation where you want to be compelled to apply to so many other areas, which is very expensive and may have no effect, or you may not even be going into those other markets. The next is the fact that there are still laws in our country that impede competition principles. The other is we don't have a clear mechanism, though we are coming up with frameworks for sharing information, and you know that most of their clients will be very keen about what goes out in terms of the information, because this is very sensitive to the respective enterprise. So we are coming up with basically frameworks on how to share this. The last one is the expansive mandate. That has also been mentioned. We have a very expansive mandate, and even ourselves realize that this is not in our interest. If you're doing a small transaction of 100 million, I don't think you need to come for approval. So what we've done here is we have already come up with a list of amendments to the Act so that we excuse small transactions. In fact, our approach is we will just give block exemptions once the law is amended, and also we'll give excusal to small mergers. So we'll have regulations to operationalize that. So we'll basically be saying any merger below 1 billion shillings, you don't need to come for approval by the authority. So I thank you very much for listening to me.